Justice.
Yes.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados. Hearing of CCJ Appeal BBCV number 3 of 2019 between Chefette Restaurants and Orlando Harris. Hearing this appeal are their honors, Mr. Justice Saunders, President, Mr. Justice Witt, Mr. Justice Anderson, Mr. Justice Barrow, and Mr. Justice Jamadar. Please state your appearances for the court.
Please, Your Honors, my name is Sachi Kissoon, and I appear for the appellant, Chefette Restaurants Limited. With me is Mr. Benjamin Briggs.
May it please Your Honors, I am Gregory Nichols. I appear on behalf of the respondent, Orlando Harris, and with me is Mr. Kashka Motley and Mr. Dimitri Adams.
Yes. Good morning, Counsel.
Good morning.
This morning is the first time we are going to have a sit-in since the very regrettable passing of Lady Waldron, who was a member of our commission. And I think that it is fitting that we should observe a minute's silence before we commence the proceedings. Thank you very much. Yes, Mr. Kissoon.
Please, Your Honors, before we do commence the appeal, if I could just carry on with the court's considerations to Lady Waldron's family. I think it's important to note, and it's an unfortunate occasion to remark that Lady Waldron actually was, for many years, the substantive counsel for Chefette Restaurants Limited. So it's with regret that we are here this morning to argue a matter. I'm sure the result of which one may actually be very critical. And on behalf of Chefette, we would offer condolences to our family and appreciate the silence.
Yes, thank you.
Your Honors, I would like to associate myself with the comments of my learned friend. I've known Lady Waldron for a very long time. My last interaction with her was she actually hired me as an arbitrator to determine a dispute between her client and an insurance company in Barbados. And I do dare say that I think that I was held in high esteem by her. Certainly we at the bar really sadly regret her untimely passing. So I am grateful that the court did honor her in this way. Thank you.
Yes, thank you. Yes, Mr. Kissoon. Yes, please.
Good morning, Your Honors.
Morning.
This is an appeal today from the Court of Appeal of Barbados, the first employment rights matter that was ventilated, and both sides have presented hopefully somewhat comprehensive submissions, and I wouldn't seek to detain the court extremely long to recite any of them naturally, but would welcome the opportunity to highlight, perhaps bullet point, some of the areas that we as the appellant consider to be most helpful in determining the matter. The notice of appeal, as currently drawn, has 10 grounds. The court will note from the submissions of the appellant that we have abandoned ground 8. We will not be arguing ground 8, and therefore that leaves the balance. Grounds 1 through 4 have, I think we've seen in the submissions, significant interrelation that I would just address in point form on those grounds. Those grounds deal with the decision of the Court of Appeal of Barbados to disassociate itself from jurisdiction to hear any matters relevant to the issue of the tribunal, where they found that issues were those of fact or associated with fact. And I can start there. We're very clear and very aware that Section 48 of the Employment Rights Act does preclude appeals on matters of anything but law. And in our submissions, we start off frontally by indicating that the areas that we wish this court to review cause us trouble because they are not purely matters of law, or in the case we cited of Dobie, there are significant issues where the tribunal has made decisions on an analysis of the facts that were before it that no reasonable tribunal, we say, could have made the determinations that it has made. And those are pointedly in relation, for example, to the issue as to whether or not the first hearing that Mr. Harris attended with Chefette was a disciplinary hearing or an investigative one. And whereas I'm very aware that the facts were highlighted in great detail in both submissions, I think in point form it's just useful to remind that Mr. Harris was a long-standing employee of Chefette Restaurants, 14 years as a manager, the capacity in which he commenced. And at the beginning of that, at the commencement, he actually had some significant training in an area which ultimately caused the issue, cash handling. So we know that he had 6 months training there, and he had also been presented with the cash handling manual and so on. But importantly, in that manual, and it does arise in the evidence, one of the things that Mr. Harris would have been most aware of, or ought to have been, we say, was that in the circumstances where he was dealing with reconciling checks at the end of a shift, he was obliged to look at the front and back of a check. It is very unfortunate that the matter before this court deals with an amount so trivial in the scheme of things, and that's a fact that wasn't lost on the tribunal, nor was it lost on the Court of Appeal. However,
sorry, could you just pause for 1 second? You said that he was obliged to look at the front and the back of the check. What obliged him to do that? Was that some rule, some procedure?
The cash handling procedure manual. As a matter of interest, the Court of Appeal did confirm that that was a part of his duties. When we look at the decision of the Court of Appeal, I crave your indulgence, that appears at pages 10 to 72 of the record. In fact, if I could take the court to page 12 of the record specifically, paragraph 5 of the decision of the Court of Appeal, page 12 of the record, which is (12 of 72). Of the record. I don't know if my friend can put that on the screen just to accommodate.
It's 5.
That's the judgment of the Court of Appeal?
The judgment of the Court of Appeal? That's correct.
Where it describes the cash handling procedures.
Exactly, exactly.
So could you
Yes,
point
it's-
out the
it's
rule?
Point 4, Roman numeral 4. The manager must verify that the information on the front and back of the check is correct.
Okay.
Yeah. So as a part of his training, he would have been obliged, as we say, to have done.
Not to be too punctilious, but what is he required to do in relation to the information at the back of the check?
The
Not the amount, is it?
well, the amount typically wouldn't be on the back, though.
Clearly, exactly.
No. But
The what wouldn't be on the back? I'm sorry.
Amount.
amount, I believe
Yes,
His Honor had
yes.
indicated the amount. The amount wouldn't be on the back, but recalling that this was an issue where the signature was in issue, at least before the tribunal, and the signature was said to be his, O'Harris. So.
Well, it was said by Chefette to be his.
Said by Chefette, that's correct. Not by Mr. Harris, but by Chefette. So in the process of reconciling the checks and the monies and so on that night in question, one of the things that he would have done would have been, or ought to have been, to look at the back of this check. And of course, if O'Harris presented itself there and he didn't sign it, that would have created a bit of a problem, or should have, for him.
Yes.
Yes. So that was a part of the background which led to the investigation being commenced into the matter. There was a complaint, and we know that the person to whom the check was written complains that she didn't receive this money, and there was a search put out for the check, and it was later revealed that the check was deposited in the bank, so it would have been endorsed and became a part of the deposit. What is interesting, and I just pause because it's caused me some concern, throughout the tribunal and in fact in the Court of Appeal, there was much of a muchness about the fact that the figures actually reconciled. And there then seemed to be some resting on the fact that suggested that nothing was wrong. But it's the fact that the figures reconciled that creates the problem, because that meant that the cash equaled out with the checks. And in those circumstances, it meant that the cash, which was equal to that check, would have been removed. So it had to reconcile. If it didn't, then I think there would have been an issue. The fact that it reconciled meant that the cash representing the check amount no longer existed, and therefore it reconciled. So it's a simple arithmetic issue, but it seems to have been a focus before the tribunal and before the Court of Appeal, as if to say, the fact that it reconciled ends the matter. Nothing was done wrong.
Okay, but let's just say that he neglected to look at the back of the check. Then he would have been entitled to the view that the checks reconciled with the cash.
If he looks at the back of the check?
No, if he didn't look at the back to know that
Yes, he would have been entitled.
O'Harris was at the back, he would
That's
have been
right.
entitled to say, well, everything is fine here.
Without more, there wouldn't have been a trigger for him, I would have imagined.
So Chefette would have taken the position they did, assuming they didn't think that he stole the money, and that was not the ostensible or the stated reason on which Chefette said that it dismissed him.
Correct.
It said that it dismissed him because he failed to observe the cash handling procedure.
Correct.
The particulars of that failure, you say, is his neglect to look at the back.
Had he looked at the back of the check, and his position is, I didn't sign that check as revealed from what we call the investigative meeting, then that would have triggered, or ought to have triggered for him on that occasion, because if he had signed that check,
Right.
no issue. If he hadn't, I think that that would be justifiable to say that he would have expressed some concern or surprise.
But the failure to look at the back of the check is something which is clearly not as egregious as stealing the money.
I agree. That is correct.
Wouldn't that failure be something which, well, let me put it in an open way. Would that failure be something which warranted dismissal?
When one looks at the fact that this is a manager that's responsible as a gatekeeper for ensuring that financial matters are run properly, then yes. It is unfortunate, and I do say frontally that this concerns $40, but it could have been $400,000. The issue that led to the departure of that money is the problem. So it's the gravity of the failure as opposed to, for example, the amount of failure. And in these circumstances, what led to that failure was
Yeah,
negligence.
but you can't really disassociate the amount from the failure, can you? I mean, if $1 million was on the front,
You'd have checked the back, clearly.
then there would have been a much greater onus on him to check the back than if there's only $40.
I don't know that that appears from the procedures. I believe that the fact of checks being presented is by itself enough of a requirement for him to be cautious and careful, to the extent that he is safeguarding property. And as I say, I do appreciate we are talking about $40, but I don't know that there's any evidence that had it been $1 million, that anything different would have occurred. And that's the
No, we
danger.
can't say that. We can't say that.
We can't, no, and I
No,
agree.
So we just have to approach it from the standpoint of what is reasonable, what a reasonable person would or would not do or may not do. As a matter of interest, were any disciplinary proceedings taken against the cashier?
No.
I see. So that wouldn't this may have been a basis on which the tribunal took the view that the real reason was not really the failure to look at the back of the check. The real reason was Chefette's belief that he stole the money.
Well, if we look back at what happened, I think that the answer to that would be no. Because again, it's tempting to go there, and I agree that on first blush, perhaps someone would. But when you look at the context of how this happened, there was an investigation. Whether or not the tribunal, and we'll come to that hopefully in the ground that deals with that, when the investigation is being conducted, we have one person who, from the evidence, is tending to be confrontational, doesn't want to participate to the extent that he actually has an exchange with the then industrial relations manager, Mr. Harvey, and it's as a result of that quarrel that he was suspended. I think it's important to note, not because of the actual issue of the check and so on, and that's apparent on the evidence. But that exchange leads to the need for the disciplinary hearing. We haven't got to that point yet because we're still at the investigative process. It's akin to someone being charged and a suspect is interviewed. In this case, everyone was interviewed. There's nobody being singled out as being the culprit or the person responsible, if that's the better term. But his behavior and his remonstration and his uncooperative nature, even when asked to come to a disciplinary hearing, results in him being focused on as the person.
I'm not sure you can take away his reaction from the entire context, because obviously he felt that he was being accused of theft.
I agree.
Of $40, and he had worked with the company for what, 14 years? And he
14
was
years.
obviously quite incensed by that accusation.
I quite agree.
Yes.
I don't take
His
away from that.
response, I mean, the question is it all that unreasonable, especially since he asked for a handwriting expert, he asked for the matter to be referred to the police, his name could be cleared. His response, is that all that unreasonable in the circumstances?
His response isn't unreasonable. I believe anybody else in that circumstance reasonably maybe may choose or may not choose, but may react that way. And that's understandable, but it is his later uncooperative behavior, not his reaction in the meeting, that leads Chefette to have no other choice. He didn't appear for the disciplinary meeting. His attorney suggested, and that's on the evidence, as a courtesy, you should go, but he didn't. So there's more to it than merely, I'm upset because you've accused me of something. We've moved beyond that. We've moved beyond the upset on that day. He hasn't been fired for being upset. He hasn't been terminated for being upset. So that's understandable. What's happened is he's now uncooperative in the whole investigative process or the disciplinary process. And how do we treat to that? Is that something that we are to ignore? I don't believe that that could possibly be the correct thing to do. When you have an employee who is being asked to answer to a particular issue, and that issue, though it does concern $40, is important, is a critical issue. He is a manager. That's part of the issue that we have with the way that it has been treated before the tribunal and the Court of Appeal. This isn't about $40. You have a 14-year veteran manager who ought to know better. And then, yes, he has a problem with being questioned because he feels he's being accused, but then he doesn't cooperate beyond that. And that doesn't, in our respectful view, send a very good signal to the employer. They're trying to get to the bottom of this. Yes, you're upset, but you then don't take any active part in the disciplinary hearing.
Yeah, but
Was he dismissed because he didn't cooperate?
No.
So he was dismissed because he didn't look at the back of the check.
a $40 check.
Again, it's a difficult position, but that is.
But was that accusation put to him in writing? You did not look at the back of the check, and therefore you now suffer
No,
damages of $40. That means he caused the company in 14 years a $40 deficit.
that is accurate. I don't think there's a dispute on
That
that.
is the reason why he should be dismissed.
No, it isn't. It's because the fact exists that it's conduct of a level. The $40 is the unfortunate red herring, and it seems to have permeated.
Mr. Kisuna, I take exception at that. You can't say that. $40 is $40. $40 is not $1 million.
And whereas
And what is reasonable in relation to 40, or put it this way, what is unreasonable in relation to $1 million may well not be unreasonable in relation to $40.
I take the point, Your Honor. I don't mean to be derisive about it. It's just that the reality is the fact of money being in the conduct of a guardian, senior employee of the company, and that particular type of behavior is covered under a code of conduct under which he's a part in terms of the contractual
Mr.
arrangement.
Kissoon, you see, I think that where the conversation has reached is a little more nuanced than that. I think that you accept that it is $40. I think you accept that the fault, according to the manual, was the lack of care to check the back. And you reasonably suggest that if he hadn't seen his name and he had not issued the check, then he would have been put on notice. So let us accept that maybe there was a shortcoming on his part in that regard. Let's assume that that is so. I think what both the President and Justice Witt are raising with you is, assuming that that is so, what does, in the context of fairness, what does an employer do? Does the employer call the person to say, well, listen, you know, this check was issued, your name is at the back, how come you didn't pick it up? That's the charge. The charge is, the investigation is, how come you didn't pick it up? There may be an explanation, we don't know, because as you have answered to Justice Witt, that was never put to him in writing.
Correct.
All right. You then say, well, as we go forward, what compounds things really is how he behaves. He does not cooperate. But there's a bit of a sort of a catch-22 there. Because if what was put to him is that you did not check the back of the check, and that's what we are unhappy with, because as a manager you need to be, suppose it was $1 million, then what? Legitimate? He may have behaved very differently. So that to hold against him his lack of cooperation, when you never put to him what the concern, legitimate as it may be, was that fair to him? Because, and then on your side, to compound your action, you never then say to him when you hit disciplinary proceedings that, hold on, what has brought about this dismissal is a series of events. A, the non-compliance with the manual requirement, that's a formality, you should have done it, but compounded by, as a manager, your uncooperative attitude, or however you chose to describe it, in relation to this investigation. Does the documentation disclose anywhere that either or both of those things were put to him as the complaint, concern, whatever?
No, the meeting with Mr. Harris on that day did not get as far as, and I think when one reviews the actual exchange that occurred between Mr. Harvey, the other persons in the room, and Mr. Harris, we can see that it wasn't a completed meeting. It was one that was interrupted by the fact of this exchange.
At any stage after that, you could have put in writing to him that, listen, this meeting was aborted, and therefore we want to put to you on the record what our concern is. Our concern is non-compliance with X4 of the manual and your whatever adjective you use in relation to cooperation. And we invite you to put your response or explanation in writing. That would be fair, won't it?
That would be one of the things that would be fair.
No, but you say the nub is non-compliance with the manual and non-cooperation.
Yes.
Yet still, at no stage in the process have you ever put that to him.
Well, respectfully, Your Honor, the fact is that we have put to him that he is in breach of that cash handling. That's in the invitation to the disciplinary meeting. So I take Your Honor's point that the specific granular detail of the complaint which I just raised was not.
Okay.
However, the invitation to the disciplinary meeting, which invitation was issued on the 30th of December, 2013.
Does have the non-compliance with Part 4 of this manual. This what you brought our attention to.
Yes, the cash handling procedures. So that is in there.
No. Does it have not? Is it general or is it specific to what you've read to us? The manager must verify the information at the front and back of the check. No, that's the general, but the particular of the offense is
no, it's not as specific as that.
In relation to this check, you did not look at the back, or you would have recognized that. Was that particular right? You just can't say.
No, I
you
just
didn't look at the
confirmed.
book.
I confirmed to the court.
There's a lot in the book.
Yeah, no, I confirmed to the court that that specific granular approach, which was one of the approaches that could have been taken, was not.
But in fairness, Mr. Kisoon, if you are to bring a complaint against somebody, doesn't fairness require you to particularize with enough clarity so that they can know the charge that they must answer?
I agree with the court.
All right.
And one of the tests that comes out in these types of matters is, in fact, very much that, reasonableness. And that I understand is what we're discussing, because obviously $40, is it reasonable? And I do appreciate that. But they're also...
I'm not on the $40, you know.
No, I understand.
I am on your point about the fairness of the process to...
I understand. I completely understand, Your Honor. I was raising that to show that to get to the reasonableness of whether or not it was fair to be general in the invitation to the meeting as opposed to the specific granularity of saying you did not look at the back of the check in breach of this. I understand the court's position on that.
And that was not done.
That was not done. But that does not equate with the dismissal being unfair. Because to answer the court's question, yes, it would have been fair
to have done it that way. But it doesn't mean that by answering in that manner that the opposite is also true, that to not do it is unfair. Because there is nothing to suggest that it is, other than what is set out in the Schedule 4, Part B, there's nothing to suggest the granularity that Your Honor, with legal training, has suggested today. We are talking about a layperson employer. So whereas we can have that exchange and discussion, and I agree with the court, reasonableness is more than that. If it is that I was having that exchange with the court and I as counsel did not do that particular granularity, no, it would certainly not be fair because that person didn't have the opportunity and so on, given my experience, understanding, and knowledge of what should go into it. So reasonableness also takes into account the employer.
Could you go back to that requirement that the manager must verify that the information on the front and back of the check is correct? Now,
Yes.
where is that to be found?
Is there a manual in which that is recorded?
It is in the cash handling procedures. If the court will just permit me a moment, I will actually go to it. The pages or the extract from the cash handling procedures manual is found at our tab 26, which is page 605 of the record.
Yes.
605.
And crave indulgence whilst I get there myself. So that part of the bundle will have Chefette logo, and it'll say cash handling procedures beginning at and in fairness, what's before the court on that extract
Doesn't say it, huh?
doesn't say that. So I would have to refer to the Court of Appeals decision just to make sure that I
Yeah, but you
can
see,
pull that.
we have a problem because we did not find in the evidence anything that suggested that he, as the Court of Appeals said in paragraph 5 there, that either there was a manual with this in it or that he was trained.
Or it was what?
With it.
Yes, sir.
Either that there was a manual with this requirement, that noted this requirement, or that he was trained to observe that requirement.
I mean, what happened is that Mr. Harvey gave testimony for Chefette, and he said that this is part of the training, but where is that in the official manual?
And the thing is that the way in which it is stated in the Court of Appeal judgment suggests that 14 years ago, when he was being trained, he was told, or they say trained, I don't know what trained means there in that context, about this front and back. 14 years when he was being...
Yes.
So you again, that sheds some light on the extent to which it can be held against him 14 years later, that he didn't look at the back.
I appreciate that, Your Honor. It is a fact, but yes, the weight of it would look into the reasonableness that we were speaking about. How reasonable would it be? And we do appreciate that point. I just take a pause to mention for just a brief moment that a part of Chefette's appeal in this, and I think we've said in our submissions, but just to remind, is that there have been other things that have emerged in the Court of Appeal decision which have caused consternation, and we're seeking clarification. And I want to be very clear on that as a part of this process. Certainly, there were things that an employer with adequate precedent and authority and guidance from a court would do somewhat differently. There was at this stage of the Employment Rights Act, and again, this is the first case that's coming before any court, there was no guidance on what it is that would be reasonable. So the employers are figuring it out as we go along. Mm-hmm. And that's a part of the reasonableness test as well, and I would ask that the court consider that in the context of Chefette making this type of decision in terms of how it was done. This is 2013, just a short spell after, in fact, in the same year that the Act is actually introduced. And this is something that was new to all employers and employees in Barbados. And the benefit of hindsight and precedent is exceptionally helpful to those of us who practice in the area and may seek to advise. But certainly at the time when this Act, fresh as it was in force and they were operating on it, there was no guidance at all. And I believe from even the cases that we have looked at, reasonableness ought to take that into account as well.
Now, tell me something. I wanted to get a clearer idea about how this transaction would, or transactions of this nature would normally proceed. So, Chefette writes a check to Donnellan Ward.
Yes.
She is allowed to take that check and not to go to the bank with it, but to go to a Chefette cashier and to give the cashier the check
and endorse
get
it
cash.
back to Chefette.
Endorse the back and get cash.
Yes.
And then the cashier ultimately, at the end of the day, will send that check to the bank on which it is drawn.
To be redeposited into Chefette's account. That would seem to be, and I understood it that way as well, Your Honor.
I see. So the cashier would have paid out $40 to someone other than Donnellan Ward.
Well, I can't say that the cashier did. I can say that a check was endorsed to someone other than Donnellan Ward.
Yeah, but who has the physical cash?
It would have been or ought to have been the cashier, but we don't have that information. I'm in no better position in the court on that. It doesn't reveal from the record.
No, just a
The
minute.
finding of the tribunal was that Chefette had to pay the $40 out.
Yes.
Yeah.
Subsequent to that, but I was of the view that the court, Mr. President was speaking about the night of the matter. But yes, later on there had to be a compensation to Ms. Ward because she wasn't,
So she did not get the $40.
initially, no.
So somebody other than Ms. Ward got the proceeds of that check.
Yes.
That's the point. Okay.
And got it from a Chefette cashier or from the bank?
From Chefette cashier on the night in question.
So that a Chefette cashier on the night in question, the likelihood is, paid $40 to somebody in exchange for receiving that check.
That would be the assumption, but because that doesn't emerge, I can only offer that that should have been what
That
should have
is
been.
But
what
Mr.
seems
Kisoon,
likely.
why you say should? Weren't the accounts reconciled?
The accounts are reconciled. My answer to the,
But if the accounts are reconciled, it means that the money had to have been paid out.
yes, but I don't know that it was the cashier, and I believe that's what the court was saying.
You mean, okay, you're
I don't
focusing on,
know the
you're
answer.
focusing on the cashier.
Well,
not
because the
fact
court
that
asked me.
payment out. Right, okay.
I don't
okay,
know
fair enough.
that answer.
Yeah.
Right.
But
Who else could get then the money from the cash, the cash money?
I would need,
Who else but the cashier?
I don't know.
whereas I agree with the court, the
We
evidence
don't
doesn't
know those
assist me
details.
in saying that definitively, and I couldn't offer it.
Yeah, okay.
But I agree. It would seem to me that based on what the understanding was, it would only be the cashier, but I couldn't properly say to the court that it was only the cashier.
I would like for you, Mr. Kisoon, to locate, assuming that you are correct, that there was in fact a breach of the cash handling procedures.
Yeah.
And that's an assumption which is not irrebuttable. But assuming there was, how do you locate that in relation to the law, which says that that justifies the dismissal of Mr. Harris?
We have relied on the contractual arrangement with Mr. Harris and Chefette in terms of saying that that type of, to use the term conduct, would have, on the first instance of it occurring, warranted or given Chefette the right to terminate on the first instance. And that's at the clause 11 of the manual.
That's negligence in relation to treating with the property of...
Yes, that's the one.
Yes. There is also offense 10, which seemed
There's a 10 as well.
quite similar to me and which involved different steps in the process.
That's
Why is
offense.
it not on the 10 as distinct from 11?
I imagine, Your Honor, that if there are two exits available and one is closer, you take that one. And whichever exit gives the best egress, you proceed through it. There's no requirement that you must go to the other one.
And how does that sort of contractual relationship then links back to the statute?
Well, the Court of Appeal found that that was contracting out, and our submissions dealt with that, and there is, from the submissions, the Court may have gleaned that we are not of the view that there is any contracting out at all. There's nothing that is abhorrent nor inconsistent with the provisions of the Employment Rights Act that would indicate that that type of contractual arrangement would be afoul of any specific area under the Employment Rights Act.
You quoted a passage, I believe, from Halsbury,
No, from Benyon.
but there was a
maxim.
passage quoted from Halsbury.
I believe counsel in the court below may have done
I
so.
have done that, right. Because that passage also required that the dismissal be fair.
Yes, and the Halsbury quote, which was referenced in the tribunal and in the Court of Appeal by counsel below, did indicate that it should also be fair.
Yes.
Yes.
And when you're talking about fairness, you also have to talk about reasonableness. I don't want to go back to the discussion we had before.
That's our view, and that's part of the reason that we say we're here. And ground 5 is the one that we speak about, the band of reasonableness, which we've asked the court to engage on, because of course the Court of Appeal below suggests that that band of reasonable test has no place in the Barbados jurisprudence. And of course we've asked this court to hold differently and to offer guidance in that area, given that this decision is as important as the Court of Appeal has endorsed that it is.
Yes.
We've asked this court to give us that guidance.
I don't want to dictate the pace at which you go, and of course, that's the function of the president.
Yes.
But I particularly wanted to hear you on the other ground of appeal. I don't know if we're ready for that, President. The compensation.
Before we get there, let's just sum up the first foreground. You're saying that the Court of Appeal wrongly denied itself the jurisdiction to determine whether the tribunal had gotten it right on the facts.
Yes.
Because if the tribunal had reached a decision which no reasonable tribunal could arrive at, then that is a decision of law, which can be reviewed.
Which is what Dobie suggests.
Yes, and that's your submission.
That's my submission.
And you're saying the tribunal should have reached what decision?
That they should have reached a decision, principally that the first meeting was an investigative one. And having made an error in that, then they led themselves into other error based on the procedural implications which arose as a result of that. And having not examined that, the Court of Appeal then held fast to the view that immediately this was a procedural faux pas, end of story, or as they say, end of the matter.
Okay.
And that captures grounds 1 to 4.
Okay, what's ground 5?
Ground 5 is the crave indulgence one. Ground 5 is the band of reasonableness test that we were just on.
Okay, well, that's a matter of law which it's a question as to whether this band of reasonableness test
Applies.
should be imported into or it's
Into the
part
Barbados,
of
yes.
Barbados jurisprudence. But doesn't that simply suggest that, look, there's a spectrum on which reasonableness lies?
Yes, Your
So
Honor.
what's the objection to that?
We don't have one. The Court of Appeal has said that the band of reasonable test doesn't apply to Barbados.
Oh, I see.
And we're saying that, well, it does, and it ought to, and here's why.
Okay.
So, no, we agree with the court, so, or, sorry, we agree with that.
What's your ground 6?
Ground 6 is the, similar to the the ground 6 deals with the standard that the Court of Appeals suggested needed to be imported was too high. They're suggesting, for example, that it was reasonable to conclude that the investigation was not properly carried out, or that it was at an end at the time when the first hearing, what we call the investigative meeting, occurred, and they imported too high a standard. When we actually examined the exchange that occurred and the evidence of Mr. Harvey, Mr. Harris himself, it was clear that the investigative process was still continuing, and there was a complete ignoring of those salient points and those salient bits of evidence which would have supported that that was in fact occurring. We've also said that in terms of the investigation itself, and we've relied on UK authorities on the point that required to do more than a reasonable employee. The tribunal saying Chefette has the resources to do this. And that bald statement finds no place in the evidence. It's an assumption, perhaps because notably we know what Chefette is, but certainly that doesn't exist in the evidence. And
So the tribunal isn't entitled to take notice of the nature of the Chefette.
I can't say that it would, to the extent that it can go as far as saying it had the resources to do what? There's been no expression on the record of what it is that it had the resources to do.
But the man was saying that, look, you needed to carry out
thing he wanted done, that is equating with unfairness.
If
Because
a man believes that he's being accused of theft, which is a serious imputation on his reputation, apart from everything else, then isn't it reasonable that before that imputation should be made, or before a conclusion should be reached on that imputation, that a proper forensic examination be done of the material that leads one to that conclusion?
the case law suggests no, Your Honor. If I can take the court to Sainsbury, which is at paragraph 102 of our submissions, we actually highlight what the court there says about the type of investigation that was happening here. And 102, Sainsbury says, the investigation carried out by Sainsbury was not for the purpose of determining, as one would in a court of law, whether Mr. Hitt was guilty or not guilty of the theft, in that case of razor blades. The purpose of the investigation was to establish whether there were reasonable grounds for the belief that they had formed. So there is no requirement to go as far as the tribunal is suggesting. That's importing a standard that's higher than required or reasonable in the circumstances of what exists, so that employers now are going to be faced with this high hurdle of saying, if you want to say to an employer who is, by your reasonable suspicion, responsible for some act, you've got to go all hog, because otherwise you're going to probably be considered to have unfairly dismissed them, and that cannot be correct.
All I would say on this is that reasonableness is not a subjective test. It's not, yeah, and the employer simply cannot say, well, I reasonably believe that you stole $40 and is given a pass because, well, that's what they said. They reasonably believe it. Reasonableness is an objective test.
I believe it is an objective test, and it comes within a band. And we think that that's where the Court of Appeal has given guidance that's not as helpful as it intended on initially being, because it's confused those issues greatly by limiting what is or what an arbiter could look at in terms of what is reasonable. So this exchange that we're having, this discussion, suggests that there is a band, that it may be that a Chefette, and we're not remotely suggesting that it may have the resources, but someone else may not. So you have to look at that. And the Court of Appeal has said, That's not what you do. There's no band. There's no application of that sort of test to this type of matter. And we say that cannot be right. Of course, that's the other ground. But I'm sticking with this ground. The standard that has been applied in this for an employer, don't mind if it's Chefette or the sole fishmonger who employs one person, the standard has to make sense. And it's too high in this particular case, given Sainsbury. And we
Of course, we didn't investigate the signature because we believe. The problem is that he didn't look at the back of the check.
You
He didn't
time?
see that it was a false signature. But you're not saying that, but that is the official reason. Saying that he directions, but that cannot be. It's either or.
I promise I'm not trying to ride two horses, Your Honor. Mark,
Yes.
how did this signature get on the back of this check? And it never developed into an area that allowed for an answer, because of course Mr. Harris got upset or offended at his belief that he was being accused. I mean, well, what the hearing evidence would show that. So we never got to the opportunity of saying it was or was not Mr. Harris's signature, or that he didn't look at the back of the check. But certainly the cash handling procedures and his breach of it was the general nomenclature that we would have,
You took the closest exit, as you said
we
earlier.
took the closest exit.
Understood.
But then by taking that exit, you closed the other one.
Once we were out through the exit, I suppose there was no need to go back to the other one.
The question is, Counsel, that the tribunal thought that much more was required than simply a consideration as to the investigation of the signature.
Except, Your Honor, that, if I may be so bold, the tribunal may have been riding two horses. Because on one point, they say that not enough was done,
Right.
but yet they say that the investigation was concluded on the 9th of December, when they say, Chefette, that investigations were still ongoing. So I find that a difficult error.
I don't know about the significance of that date, Counsel, but I'm looking at page 367 of the record. And this is where the tribunal discusses the scope or the ambit of the investigation that ought to have been conducted.
If the court can take me to the paragraph?
Well, like I said, it's at 367.
Yes,
And you have your Sainsbury at
Yes.
the
I see.
second half of that 367.
Indeed.
So that was the investigation which needed to be carried out. You go over to 368. In comparison, the respondent in the instant case limited its interview to the claimant and the cashier and does not appear to have looked beyond the documents which form part of the deposit history. And it continues, a reasonable employer might have inferred from the available evidence that it was more probable than not that the claimant was careless, etc. And then there are the things listed, 1, 2, 3, 4, 5, which were not done. And then there's this lovely passage right after the Roman numerals. A reasonable employer would also have sought to ascertain why an experienced employee intent on stealing his co-worker's money would have endorsed that check with his own signature rather than with that of the payee. And then the conclusion, in the circumstances, the tribunal concludes that when the respondent made the decision to dismiss, it had not carried out as much investigation into the matter as was reasonable, even though, in our opinion, the respondent had the resources necessary to do so.
I agree. Your Honor, the tribunal imported a reason other than that given by Chefette. Chefette said, you failed to follow the cash handling procedures. And we agree. That's exactly what they complained about.
Yeah.
It's the tribunal that says, no, you really say he stole. And we agree that that doesn't make sense.
You agree what?
That doesn't make sense.
It does not make sense?
It doesn't make sense. It can make sense because I agree with Your Honor, that for him to have signed it at the back in that manner would not have been a helpful.
All right, you're not agreeing with me. This is what the tribunal said.
I'm agreeing with the fact that that's what it says, but
Yeah.
I'm agreeing that it doesn't make, I was of the view the court had said that it didn't make sense for him to sign the back.
Yes.
Because that doesn't appear from this. But certainly that statement,
No, I'm saying that that appears from this.
the statement that him signing the back of the check would not make sense?
Correct.
Yes.
Below, Roman 5 on page 368, a reasonable employer would also have sought to ascertain why an experienced employee in.
Yes, yes,
Yeah.
I see it,
So
Your Honor.
that's theirs.
Yes, that's theirs. But I agree that that's their reason, not Chefette's.
You're saying then that the tribunal proceeded on a course that suggested, consistent with the concept of rare reason, that you were accusing the man of theft, but you were not. You were really accusing him of not following cash handling procedures.
Well, correct. That is exactly what Chefette has maintained. Nowhere in their case have they said that Mr. Harris stole this money. That doesn't appear. It's the tribunal that says that's what Chefette is saying.
And what you say is that what follows from that, like a domino effect, requirements, standards of investigation, etc., that are, first of all, irrelevant to what the Chefette's case is, but also miss the mark because they are, maybe for theft, they could have been reasonable, but not
Yes.
for mishandling the check the way you have framed the case.
Yes, Your Honor, that is precisely what Chefette
That's
said.
what's Wensbury unreasonable and therefore amounts to an error of law,
Yes, Your Honor.
right? Okay, good.
Okay, there's a problem with your microphone that our technicians say can be fixed in 3-4 minutes. And so we would, tell me what else you have to argue, first of all.
Well, I believe that Justice Anderson had questioned on the compensation.
Compensation, right,
And
that's-
that would be the only other area that I think we could.
So we take a 5-minute break and then we'll, it seems to have sorted out?
Right.
Okay. Okay, all right. So let's hear you on the compensation issue now.
Yeah, the compensation issue is one that was before the Court of Appeal when the issue of the payment of the 2 months' notice first came up. Compensation was one of the grounds that the Court of Appeal was invited to review. And we've actually set that out in our submissions as well. But this ground is a bit broader than that, admittedly, and it goes to the aspect of what the tribunal has done here in terms of not limiting in any way the amount that Part 1B of the fifth schedule could allow them to award as damages. And in neat form, there are two parts to the argument. We're first saying there are procedural irregularities in terms of not being allowed or permitted to canvass by way of cross-examination what it is that Mr. Harris did immediately post-termination that would have been to mitigate his damages and loss and would have perhaps been useful in the context of limiting the amount of time that could be reasonable to make an award under 1B. We don't know how many resumes, we set that out in the submissions, and that's because the tribunal stopped counsel from cross-examining, and the exchange we've highlighted, and it said they basically made a procedural error to say that you can't cross-examine on things that haven't yet come up in evidence. And I mean, of course, that is completely wrong in terms of what should happen in any tribunal. I know my friend has mentioned in his response submissions that these principles of natural justice and so on are common law principles, but I just seek to remind, we haven't put it in our written submissions, but this is a public body which is charged with the responsibility of determining matters relative to the public. People come to them and they award damages, and our Section 16 of the Administrative Justice Act requires natural justice to be taken into account when such bodies are adjudicating. So we say that that is a procedural irregularity that is codified. The procedural issues of natural justice are codified under our AJA.
So you say that you were not allowed to interrogate, to ask questions which would help in determining the amount of compensation that should be gotten under 1B.
1B.
Okay. Now, how do you interpret 1B? What is the benefit? What's the
Right.
ambit of this benefit?
What 1B seeks to do, I mean, I'll read it just to put it in the context. What 1B actually says, and it allows the tribunal to make awards under this section. I crave indulgence whilst I just get there.
An amount such as the tribunal thinks fit in respect of any benefit which the employee might reasonably be expected to have had.
But for the dismissal.
So is this formulation, is this to be found in other legislation outside Barbados? They must have gotten it from somewhere.
In that exact format, I haven't
You haven't seen it?
admittedly seen that.
Tribunal seems to see this benefit as lost wages, because that is what they said in their decision.
They've called it lost wages, and if in the first limb of the argument, the Chefette was allowed to cross-examine, then the mitigation feature would have come into play, because we would have said, well, you didn't do enough, you would have actually been able to have got alternate employment within 2 to 3 months. They've awarded 27 months. And that's extreme. So when we look at the word, I mean, the word reasonableness permeates this entire affair. It's also to be reasonable to an employer, the amount such as the tribunal thinks fit, that the employee might reasonably be expected to have had. 27 months can't be reasonable when the section below, which speaks to egregious conduct on the part of an employer who has behaved very badly, limits it to 52 weeks. And we've examined the Benyon on the interpretation of statutes internally inconsistent, and that is internally inconsistent. It is to create an absurd result where you have a very terrible employer who has done things that are listed in the Act that are reprehensible. There's a limitation on the damages to 52 weeks, but we have a casual misstep, if I may frame it that way, in procedure, and you can have 27 plus months and counting.
Yeah, I'm not sure you responded to the President's question. That's a negative, but what positively do you think it means?
There are two issues. You say, one, procedurally, you weren't able to elicit answers from the man, which would help the tribunal. So that's one thing. But let's get past that, whether we agree or we disagree. What, in your view, should be given under the head of 1B? What should a reason, because one way or the other, the tribunal will be looking for guidance, looking to us for some guidance.
Yes, I
on
agree.
the interpretation
If I
of
may
1B.
put it this way, in the same way that the common law existed when we had reasonable notice, it would seem to me that that type of approach could be taken with respect to this, where a person who has been off of the market related to their job title. So we know that from previous examples, and even before this court, where you may have had a senior manager and they would not have had similar employment, it's reasonable to expect 6 months to a year. That sort of approach and formulaic response would be far better suited to this limitless, capless analogy than exactly that, keeping it limitless. So it would seem to me that the common law approach could be used to seek guidance as to how a tribunal would therefore seek to limit that section so that it is also reasonable to an employer who has to find the funds to pay that person. And the common law will assist us. But if we're in any doubt, my suggestion after that is it ought not to be any more in any event than the limit circumscribed for the reprehensible conduct in C.
The problem is, for example, I think in the English legislation, this 1B, that's what they call compensatory award, and that has a cap of 1 year.
And that's the type of...
Specifically in the legislation. Now, they put a cap on the punitive award,
Yes.
and they made it also quite clear what could be the maximum of the basic award, but they didn't, the legislature did not put a cap on this one.
No, so we can run as far as we want. And that is where the unreasonable nature of that type of award comes into the fore. And in fact, in this case, we say that the 27 months where we didn't get to cross-examine, but even in the absence of that, is unreasonable. That's far beyond what would be considered, even by the language of the Act, to be reasonable.
So you're saying we should go to the common law for guidance on this?
In the absence of a cap, and given that the other parts of the Act do have a limit, then what would pertain in the common law, where you had such an employee at this level for this many years, yes, I'm suggesting the common law would be a good place to look at and for guidance.
And there's no case in which the common law would take us beyond 1C, which specifies basically.
There are.
There are.
Admittedly, there are.
So-
So it's a bit of a problem. I am respectfully submitting that our cap ought to be in line with the Act itself.
You too?
But within that cap, even though that's a limit, the guidance for how you arrive at the formula could still be referable to the age, skill set, amount of years, and so on that the common law approach would have taken, but still capping it. So we have a sort of a range of reasonableness.
In this case, the tribunal simply looked at the period between the time he was dismissed to the time he got a new job,
Exactly.
and gave him full wages throughout that time.
And what?
And gave him the full...
Yes, give him the full 27 months. That's apparent from
We're
the...
not allowed to question the extent to which, if at all, he made reasonable efforts to get a job.
The counsel who at the time had the matter was shut down on the basis that they can't cross-examine on things that have not yet emerged in the evidence.
There seems to be some confusion about the period for which he was compensated. Was it up to the time when he got the job, or was it up to the date of judgment, which was a later point in time from when he got the job?
To be frank, I was of the view that it was when he got the job.
Well, what do the facts say?
Yeah, please, sorry.
And you look at the last page, lost wages for the period of January 13, 2014 to April 13, 2016.
That's the
13th
date
of
of the
April
decision.
2016 was the day of the decision.
The court is correct. That is correct.
And got the
So
job
that's
about
even
8 months
gone
before.
beyond
Yeah.
what he would have reasonably been expected to have got till he got employment.
He was employed
He
on the
was.
date that the judgment was given.
At G4S Security. That emerged from the attempt at a cross-examination.
And for 8 months before that, I gather.
Yes, so even that is, we're at 19, we're at 18 months.
Was there
If we did
evidence
some-
given as to his salary at G4? And how that compared with at Chefette?
He did give evidence of his salary at G4. I don't have it immediately, and I can certainly search the record for it if the court wishes.
So you say that the manner in which the compensation was on the 1B arrived at was faulty?
Very much so. Very much so. Far
If-
beyond reasonable.
If we found that if we disagreed with you and found that he was unfairly dismissed, you wouldn't expect us to do that calculation, would you?
For guidance, I may request it, but we could certainly, if counsel counsel will be amenable to having that calculation, I'm certain, to have an idea of it. But again, because of the formulaic approach that may prove guidance, is the only reason that I may respectfully ask that the guidance perhaps come.
Yeah, but we could only give guidance, well, we only wish to give guidance on general principles. But
On general principles.
Or would you
But
want
that
us-
would,
Or would you want us to send it back to the tribunal?
But this is the point.
on that point, that
Because
would
you would
also
want
be
to ask your
helpful.
questions,
That would
so
be,
that there is more material on which it is possible.
yeah, because at this stage, we are operating in the dark. And I agree with that. There's no way, in fact, we would ask for the opportunity to ask those pointed questions that would guide the appropriate quantification under 1B.
Yeah.
Now, you were saying this is a decision somewhere at the beginning of the tribunal.
Yes.
It exists now for a longer period. I
They
don't
have.
know, can you tell us something? Is this now the trend of, this is more or less-
Unfortunately, it is. It's why it was important to Chefette to bring the matter on for hearing, because there has been too much of the same. And with that, there has been significant concern in Barbados on that. And I can say that the chairman of the tribunal has actually put a pause on hearings pending the outcome of this matter, because it has been seen as significant and important in the Barbados context to understand where they should go.
Is it correct that because of this approach, a lot of dismissed employees skip the Labor Department, where there's supposed to be some form of mediation, as I understand it, and go straight to the tribunal? Is that a trend?
I wouldn't say that. I think that they still are, I believe that they're still operating with the strictures of having the conciliation.
Correct.
But naturally, it's far more useful to not have a conciliation.
Okay. Great. Thank you.
Yes, that's it?
Unless I can be of any further assistance.
Okay. Mr. Nichols, let's take a 10-minute break. And then
to the Crackle Court of Justice.
Let's hear him for a little bit. Yes, Mr. Nichols.
May it please your honors, I take it obviously that the court would have read the submissions submitted on behalf of the respondent, Mr. Harris. I must confess that in relation to the last ground, in relation to compensation, I restricted my arguments to the point that this was not an issue canvassed in the Court of Appeal, and it was not an occasion, in my respectful view, for this court to go into it or to allow the appellant to basically get another bite out of the cherry, having not presented the argument in the court below. I am aware, your honors, that the tribunal has paused decisions or I should say awards thus far in anticipation of a decision from this court. However, there is quite some considerable amount of work that has come out of the tribunal in recent times, making awards under these heads. And there have been expressions as to how the tribunal thinks that these awards should go. In many instances, following the established precedents in the United Kingdom, where, and I would disagree with my learned friend, the section in the English 1996 Act is almost empowering material or section in the schedule. I think it's section 123(2)B of the English Employment Rights Act 1996 of the UK, where the question of what benefits an employee might have had but for a dismissal is very similar to our provision in our legislation. And there is ample common law authority as to what the English Employment Appeals Tribunal and the Court of Appeal in terms of reining in the awards and what are the heads of damages that are possible. And they're not sealed as the Privy Council will say, they're fairly open. And there is one important difference that we should make is that there is a cap in England. The United Kingdom Parliament has placed a cap which has to be observed, and it is not the case in Barbados. And I say from the outset that I don't think it is proper for the court to set limits as a final appellate court for a number of reasons. First of all, Parliament has given that discretion to the tribunal to determine what compensation should be awarded in the circumstances of the case. And employers, employees, the Employers Confederation, the trade unions, lawyers, we do not need the final appellate court to tell us what limit should be set. The tribunal is comprised, legal attorney at law as chairman, member of the Employers Confederation, and members of the trade union movement, experienced practitioners in industrial relations, and with a lawyer as chairman. And when Parliament sets out to create these specialized tribunals to determine particular areas of legal disputes, which ordinarily would have come to the courts, I do believe there should be some margin of appreciation to the work that these tribunals, given their experience, their expertise, their knowledge of local circumstances, would determine as to what are the appropriate limits in particular cases. And it is not for an appellate court to be, I say respectfully, to be beguiled by the arguments of my learned friend that for some reason the extensive award of damages in a particular case was too hot for the employers in Barbados. It was shocking to them. This is the first case that really came out, and therefore this court should run to the rescue of the employers in Barbados and set limits as to what the tribunal should be able to award when the Parliament of Barbados has not gone that far. And I think it is a stretch to ask the court.
Counsel, do I get the sense that you are saying that the competence of the tribunal to make an award is limitless?
No, my lord.
Well, you came pretty close.
No, I'm not. What I'm trying to say.
Tell me how far back you want to walk from that.
My lord, sorry, Your Honours, the tribunal does not have an untrammeled power to award compensation. Certainly, the compensation must follow the statutory formula.
Right.
And it should also follow established principles of law.
Okay.
You must be able to break down the decision and follow a concise, cleverly made out, reasoned decision as to how the compensation has been arrived at. And so that
Sorry. You just said the tribunal must follow established principles of law.
Yes, right.
And I take it that we are competent
Yes, you
to
are.
say what they are.
Yes, they are.
Okay, so
But what I am cautioning the court against is that to say in a particular case, 27 months is too much because this court should have given 23 or 18 months or 12 months in the circumstances.
But if we say, for instance, that 27 months or 18 months or whatever it is was fixed by reference to no known principle, that there was not any particular reference point, then it could be considered arbitrary, couldn't it?
Yes, and arbitrariness is a impeachable ground to
Therefore,
yeah.
along the same lines,
Yes.
if 27 months is awarded, or an award is made for that period, and during those 27 months, the complainant was in fact employed,
Yes.
would we not be able to say, but hold on, you cannot give this person an award equivalent to salary for loss of employment when it turns out that he had properly mitigated his damage and was in fact earning a salary?
That would be in order for both the Court of Appeal and certainly this court if the error was not picked up at the level of the Court of Appeal.
I like your walk back. Well, see how much further you want to walk.
Yeah, but I must say that in this case, if I may just draw the court to the last page of the tribunal's decision.
Yes.
There was consideration for the wages that Mr. Harris earned as a G4 Security S officer.
Okay, I don't see that.
And $11,000 was deducted, which constituted his earnings from the time he started work, I think they're about 2015, until the date of the decision.
Sorry,
Can you give us a page number?
Which page? I quaver it now, just. The last page of the decision, and that would be
Sorry, whose decision?
of
Tribunal?
the tribunal's decision.
The tribunal, right?
Yes. If you look at page 376 of the
Right.
record, you will see less wages earned between the July 2015 and April 13, 2016 at $642 per hour for 48 hours by
Okay.
4 weeks by 9.5 months, total $11,710.08. So the tribunal did take into consideration those wages. And if I can just direct the court also to the actual portion of the transcript where the tribunal chairman herself ascertained the those figures by directly putting questions to the claimant, as he then was,
Right.
as to was he employed at the present, when did he start, what was his weekly wage, how was it calculated, was he getting overtime? Page 514 of the trial record, starting at line 6, so that the tribunal did not arbitrarily make an award of 27 months. And certainly they took into consideration the respondent's mitigation of his lost wages by the much substantially reduced wages he earned as a security guard at G4S.
Okay.
So that this is not the case to lead into the general principle to rein back errant tribunal when this tribunal has in fact demonstrated it understood the principle as to the limits that could be applied to what are other benefits that an employee could receive but for the dismissal. So this is not the case.
But tell me something. Mr. Kissoon says that his side was deprived of the opportunity of eliciting relevant information that would assist the tribunal in arriving at the compensation, because he was not allowed to cross-examine on issues surrounding the length of time he was looking for the job, where he was looking, and so on and so forth. That was my understanding.
Yes, and if I may use my learned friend's phrase about being granular, when we go into the facts of the case, we realize that that argument doesn't hold water. What the tribunal was doing was to say, you are cross-examining him on the basis of evidence that is not before the tribunal. And if there are questions that have to be asked, we as the tribunal can ask these questions of the witness, but you can not. You are limited to what are contained in the witness statements of the parties. In other words, you're trying to introduce new evidence to the tribunal.
I don't understand that.
That is what was said by the
No,
chairman.
I know. I don't understand.
I don't agree with that, Malad. I mean, your honors. I said to my colleagues, cross-examination is restrained by the principle of reasonableness and relevance to the facts and issues. But the two things must be observed. One, Mr. Harris was not represented by counsel at the point in time, and that obviously, with the tribunal having to set its own procedure, would have allowed the chairman, rightly or wrongly, to make certain determinations as to fairness, as to how the proceedings will be carried out. And that is a factor that must be taken into consideration. Also, it is not that the tribunal ignored the suggestions from counsel before it in terms of that line of questioning, because Ms. Arthur did ask, I believe it's page 501 of the record, page 500 of the record, line 18, Esther Arthur, attorney at law for the respondent. After you left the respondent employment, you went to work for G4S, didn't you? You worked for G4S. Orlando Harris claimant says, at present. The next question is, oh, you are still working for G4S? Orlando Harris says, yes, ma'am. And G4S is a security company. Yes, ma'am. So that it stops there, because the chairman of the tribunal, and I don't agree with her that the cross-examination should be limited, but this is not a situation where the chairman stopped that line of cross.
If a tribunal intervenes in the fact-finding process and asks questions, isn't it normative that the tribunal then says to the parties, based on what we have asked, is there anything you would like to ask about this?
Yes.
That's nothing.
That's
standard. That's normal. That was not done here. That was not done here.
I don't believe that the tribunal opened back up the situation.
So that's one. Two, this issue of assessment of damages, quantum, is a separate aspect of the litigation. One is liability.
Yes.
And then assessment. So on whom is the evidential burden for mitigation? Because you, in the same way in a normal case, you have the burden of proof standard and then the evidential
burden, yeah.
Who has the onus to establish mitigation?
In my answer to your question, Your Honor, it would be on the employee.
The employee.
The employee.
All right. So it must be legitimate, must it not, for an employer to interrogate and be permitted to, because you say, don't put a cap, don't legislate, let's apply the common law principles, and we know what the common law principles are. You will look at opportunity, etc., to come to a reasonable figure for compensation, right?
Yes, Your Honor.
Market and what's available, etc. But that is exactly what interrogation is about. To ask Mr. Harris, qualifications, opportunities, did you take advantage? Did you send out job application letters? How many? Because Mr. Harris has to show mitigation. And
yes, he has to show.
But that was not done.
Yes.
So is that fair to the employer on the compensation side?
In a general sense, my answer honestly would be no. But in this particular case, there are certain nuances that we have to take into consideration. The point I'm making is that my reading of the limitation on the cross-examination, though I don't agree with the tribunal, was that at that stage, the concern was that this was trying to introduce new evidence into the proceedings. That was the understanding of the tribunal, rightly or wrongly.
But you have to tell us, was that right or wrong in law?
It was not. It was not correct.
It was an error of law.
Right.
Right, all right.
Right. So I do accept that, but the thing is that the tribunal cannot be faulted, or I should say, it must also take into consideration that the tribunal didn't leave it there. The tribunal went itself and inquired into those matters.
But you have accepted in our conversation that that does not meet the normative standard of fairness in an adversarial system, which is to allow the other side the opportunity to bring out things that the tribunal may not be aware of. That's what cross-examination does.
Yes.
Mr. Harris, is it correct that you, in fact, made an application to WZ and you accepted? Suppose they have that evidence. You know what I mean?
Yeah.
The tribunal does.
But in this case, it cannot be underscored that the evidence as to where he worked came from cross-examination. What my learned friend, I get when you read his skeletal arguments, his written submissions, is that they were limited at all, and that the tribunal did not have before it any evidence of whether Mr. Harris mitigated, and that is not so. I'm just saying that while I don't agree with the approach of the tribunal, I am saying that in this particular case, the initial questions as to his alternative employment came from counsel for Chefette, and the tribunal stopped there. But the tribunal did not rule out or negate the issue of mitigation. The tribunal took it upon itself to inquire extensively, so much so that it was able to discern.
Counsel, I think that extensively really is overreaching.
But no, it was able to discern.
You said the tribunal took it upon itself to inquire extensively. The tribunal did not ask. No. Did you apply for any jobs? Yes. When did you start making applications?
I accept that
How many
extensively might be
entities did
a
you
gloss.
seek employment from?
Yeah.
Is it the fact that you just decided that you would sit back and let this run and milk Chefette for whatever you could get by way of an award, etc.? These are the questions that I'm sure somebody of your vigor and perspicacity would have asked had you been representing Chefette. So, but counsel for Chefette would have been perfectly entitled to ask those questions. The fact that the tribunal elicited what was the income at a particular point in time is helpful, but far from extensively helpful. Yeah?
Yes, I would take back the word extensive. Okay. But I would say that, and maybe Chefette's counsel would have been able to go even further than where the tribunal went in its questions, but to not accept that the tribunal mitigated or took into consideration the mitigation and reduced the damages, which is not mentioned at all in the arguments of the appellant in this case, gives the impression that Chefette was unfairly disadvantaged in the proceedings and that there may have been an opportunity to reduce the damages even further when that has been done.
Counsel, you have already accepted to my brother Jamadar that it was an error of law.
Yes.
Why don't you move on?
Yes, okay.
Now, in moving on, am I to take it that, okay, fine, there was this error of law. It's an error of law that went to the issue of the computation of the assessment under 1B of that section in the schedule. And that therefore, if we agree with you that there was here an unfair dismissal, would you accept that there should be a rehearing on that question of the compensation? Or is it that you are saying that that a rehearing would make no difference because all the relevant material was still elicited?
Well, the respondent is satisfied that the answers he gave to the tribunal and the way in which they were taken into consideration to reduce the amount of damages satisfy the question as to whether he mitigated his loss. But if the court finds that that was not enough, or that the error of law was so egregious and so disadvantaged Chefette in this particular case, that the question as to compensation should be done afresh, the appropriate place for that would be to remit it to the tribunal for assessment.
Okay. Now, what is your view, and we asked this to Mr. Kissoon, what is your view of 1B? Or maybe you've already dealt with that. Do you think that the tribunal took a proper approach in taking the view that it should just give, assuming that it had all the facts that there were to be had, you accept the approach that they took? Is that the case?
Yes. One of the heads that is available to an employee who was dismissed unfairly is lost wages. And in this particular case, there is common law authority which suggests that from the date of dismissal up until the date of the award of a tribunal is the appropriate amount subject to reductions for any mitigation. So that in this particular case, it is, in my respectful view, though not extensively articulated by the tribunal, and that they did not cite relevant common law or other authorities from other similar jurisdictions, the principle or the approach, to my mind, was satisfactory, and that was all that is required.
It just seems a very awkward way, Mr. Nicholas, of stating it. 1B refers to any benefit which the employee might reasonably be expected. Why not simply say lost wages?
Lost wages.
Yeah.
You see,
it doesn't sound, because A deals with basically compensation, basic compensation. C deals with a situation where the employer has behaved very, very badly.
Yeah.
And B refers to any benefit. Now, if it was thinking in terms of lost wages, it seems a very odd way to state it, doesn't it?
The mind of the legislature is what this court is required to unravel. And I don't accept, and if you may permit me by answering your question in this way, I don't accept my learned friend's suggestion that that is incongruous with what else is settled in the section, because the punitive award in the section that follows it is limited, but that is not the only compensation that an employee who is dismissed in those circumstances will be entitled to. He will be entitled to all three, but the limit for that one, the punitive award, is set to 12 months. Now,
Well, Mr. Cook,
But I find it
I
curious that
clarify.
A is limited and C is limited and B is unlimited.
And I think that,
Council, adding to that,
Yeah.
I did want to get your view on this. One says, in a case to which the section applies, etc., the tribunal shall make an award consisting of the aggregate of the following amounts. So it's the aggregate, yeah? One, a basic award. We have seen what they did.
yes.
That is 3 weeks' wages for 14 years being the sum of 2,000, etc., 31,000.
That's almost equivalent to the redundancy payment.
No, that's equivalent
In
to...
Barbados, formulation is taken straight from the Severance Payments Act and is without much difference at all. So the basic award basically replaces what.
So this is what you get for having lost your employment and having lost your income.
No, they're different. And in fact, the English authorities make the very same point that they are not the same. The basic award is, and I know these are not damages, all right? This is an award. So the basic award expresses what the tribunal thinks should be given to someone who has been unfairly dismissed. And it places them in a situation, had there been a redundancy, and this is my interpretation of the case law, you would be no less different.
Okay.
Okay? So this is your award for having been unfairly dismissed.
Right.
Now that there are other benefits which you might be entitled to.
Yes.
And I must say that when this came out.
Would you like to allow me to finish my question? or-
Sorry.
Yeah? All right. So, A, basic award.
Yes.
And this is compensation, okay?
Yes.
We're clear on that because the umbrella word says compensation.
Yes.
Yeah? And then B, and this is a question raised by my brother, the Honorable Justice Anderson. An amount such as the tribunal thinks fit in respect of any benefit which the employee might reasonably be expected to have had but for the dismissal. Gas allowance, meal allowance, a number of other things which we can find.
Entertainment, travel,
That sort of thing.
overtime.
Right.
And the case law has gone even more extensive and other categories, and even lost wages, future lost wages, loss of promotional
It will have to be
prospects.
future lost wages in addition to or separate from the basic award, which compensates you for lost wages.
No, the basic award, in my respectful view, and in my reading of the English authorities, is not to compensate you for lost wages. Lost wages is paid or awarded by the tribunal in addition to that basic award. I must apologize.
Basic award for.
I must apologize, as I said, when I constrained my replies to my learned friend because I felt that this was not a ground that was canvassed before the Court of Appeal. But I do respect, and because I do agree with my learned friend that there has been a pause in the tribunal system because of this case, and I only discovered that after I realized that my other matters were not proceeding, and I was told by the chairman that we were waiting on this decision that I was. So I do believe that if I'm permitted by the court, we can submit a number of other authorities where the English tribunal for the similarly worded section has interpreted what other benefits are, and they include lost wages.
Right.
But so that lost wages have not been, in my reading of the English authorities, being included as part of the basic award, but as a separate head under Section B.
Those references would be useful.
Yeah, and I do apologize. Sitting at the breakfast table this morning, my colleagues are just sending me cases because obviously they have dogs in various races, but this point has been determined, and I do believe the tribunal itself has addressed this in cases after Chefette, and in more recent cases. Some of them might come here, so I wouldn't say much more. But
your point simply is that the basic award is not intended in the case law in the UK to compensate for lost wages.
No.
And that comes under the 1B benefits but for the dismissal.
Yes. What we don't have in Barbados is that there is a statutory limit in the United Kingdom.
Right.
So that it is not open-ended. So that,
This is what they call the compensatory award
yes,
in England, and it has a cap,
this is capped.
88 something
Yes,
thousand pounds, or 1 year if less.
right.
Correct?
Yes, and there may be reasons for that. It may be because the English system is able to dispose of employment claims in a much more efficient way than in Barbados. Because where there is a conciliatory process, the parties' conduct in the conciliatory process is placed before the tribunal. So that if you unreasonably don't participate in the conciliatory process, or you don't take into consideration a genuine offer, that is a factor that is taken into consideration by the tribunal determining the matter. In Barbados, the labor officer acting on behalf of the chief labor officer has no powers whatsoever to remit to the tribunal their thoughts as to the conduct of the parties, what was reasonable in the circumstances. And I dare say it would be in a run afoul of the common law without prejudice rule to reference the thoughts of the labor officer in the conciliation process to the tribunal. So that itself in Barbados presents a situation where some of us at the bar feel that perhaps you need to give more powers to the persons who conduct conciliations. But the process in the UK runs much smoother, and therefore there is an expectation that matters will conclude within a set period of time. That is not the case in Barbados. For a long time, the tribunal did not sit, and for a long time, the tribunal didn't sit. So who is to blame? And the fact of the matter is that the tribunal did find that Mr. Harris was unfairly dismissed, a unanimous decision of the tribunal. And it has taken him 27 months to get any compensation affirmed by the tribunal. He's not entitled to interest. He's not entitled to anything, but he's had to obviously mitigate his losses. But we look at the side of the employer being the victim of a award that is high. But at the same time, and this is an employee who has ordered his business in a way that he's been working for 14 years in a secure job, who has lost his job in a manner in which the tribunal has said has been unfair. And this is almost 6 years where he's been out of pocket with the matter still traveling along. And I don't think that the court has any inherent powers to award interest, even on the amounts awarded by the tribunal. And that is a point that needs to be understood as to why the tribunal should have some latitude, yes, not an untrammeled power, reined in by principles of law to make compensatory awards in the particular circumstances. They see the parties, they make assessments as to the demeanor of witnesses, and they make important decisions as it relates to the real reason for the dismissal and what was the conduct of the employer, whether they did enough in order to
Those issues don't come under 1B.
No. I'm just saying that this is what the tribunal has to do. So I'm saying that in this context, when you have a matter drags on, say, for 27 months, if lost wages are ordinarily a part of what established common law systems award unfair dismissal litigants, or litigants who have been unfairly dismissed, it is indeed in this instance proper to award it while accepting that the tribunal did not extensively elaborate the basis for the grant of the award. It's clearly a lost wages award, which is proper in the circumstances and which has been mitigated by the amount that he has earned as a security guard for G4S.
Okay, Mr. Nichols and Mr. Kisoon, we would give you, 2 weeks to submit us with further authorities and submissions
Yes.
on this issue of compensation in the event that we were to hold that he was unfairly dismissed.
Yes.
Can we hear you on that issue now?
Yes, ma'am. The tribunal, Your Honors, found that the check of $40 issued by Chefette justified disciplinary action against Mr. Harris. However, it did not find that the dismissal of Mr. Harris in the circumstances was reasonable. And it also found, and which is very important for Mr. Harris's case, that Chefette's breaches of the procedural requirements for fairness have been so many and have been so egregious that the result of it was an unfair dismissal. That is what the tribunal
Just hold on a little bit. Let's see where there is, if there is any, common ground. Does your side, do you accept that there was a cash handling procedure which required Mr. Harris to look at the back of the check?
Yes, that is clearly settled in the manual.
Okay.
So,
So,
We didn't see it in the manual, Mr. Nicholas.
Sorry, not the manual, the extract that settled on the one-page thing where it said what are the cash handling procedures for changing checks.
where is the extract from?
we were
I'm not sure where the extract is from, having not participated in the case before, but it appears in the record and it was submitted to both the tribunal and the Court of Appeal in the record that came to the Court of Appeal as part of it. But the origins of it, I am not able to assist the court as to where the
Okay,
origins.
fine. So
Your client accepts it.
you accept that.
Yes.
So, Mr. Kisoon's point is that, look, the tribunal went on a frolic of its own in arriving at this real reason, when in fact they always suggested that the reason was his failure to follow that particular cash handling procedure. And so they arrived at a conclusion that was just off the rails. They did not address the issue that he was fired because he had neglected to observe the procedure.
My response to that is, with respect to my learned friend, a fallacious argument. When we look at the invitation to the various meetings, none of them referred to cash handling, your conduct in relation to the management of checks and the non-observance of the company's cash handling procedures. The first invitation, into which Mr. Harris said he thought he was bull rushed into a meeting by telephone, was the handling of a co-worker's check, implying that this check was stolen. The very first questions that he received in that meeting were not in relation to the non-observance of the company's cash handling procedures. Explain how your signature arrives on this check. And he felt pressured. He even had to say, well, look, I wrote my signature a number of times. They were not even satisfied that his writing said, Mr. Harvey indicated, you know, your signature is never the same every time you sign it. And there was a heated discussion. They went out of the meeting, and when he came back into the meeting, the next question was to explain how your signature got on this check. So that I do not accept my learned friend's suggestion that the tribunal was so wild and frenzied that it adopted a position that the real reason was theft. I do say, however, in my submissions that whether or not it was theft or the mishandling of the cash handling procedures went to conduct and capability, which requires a certain process to be observed by a dismissing employer. That, for some reason, has not been answered by the appellant in this case, either before the tribunal or before the Court of Appeal or before your honors today. And to my mind, the Court of Appeal's application of the standard of disciplinary procedures required by the Act, mandated by the Act, have not been complied with. So that even if we have an argument as to whether it was theft or whether it was the mishandling of the cash handling procedures, it takes us relatively nowhere if we understand the statutory formulation as to how the employer should act when dismissing an employee for reasons of conduct or capability. So that is a question of fact. And my learned friend, I think, conflates the application of the facts to the law with findings of fact, because whether or not the employer, the reason was accepted by the tribunal differs from that. And Chefette is so offended by the tribunal's rejection of their reason that is come to this stage in this appeal. But whether or not it is cash handling procedures or not, it goes to conduct and capability. And therefore, the mandatory requirements for the dismissal of an employee must be complied with. So that is not an excuse. And I dare say that when we look at the disciplinary manual of Chefette, they have not explained how this particular incident could give rise to dismissal at first instance. And when we look at it, I think, my learned friend, my learned friend will put it up for you, because I want to show that it is not, it could not have been reasonable in the circumstances to leap from mishandling of the cash handling procedures of the company to dismissal. So that Chefette made up their minds before the very first meeting. And that is the reason why, in relation to the questions posed by both Mr. Justice Anderson and Mr. Justice Jamadar to my learned friend, that they couldn't explain why the initial invitation to the meeting did not set out the charge for which he was ultimately dismissed, because it was that their minds were made up that it was him who stole the money, it was him who endorsed his name on the check, and that is why even they refused to answer the initial questions he posed to them in the meeting. Who was the cashier? Did she sign the check, write the thing in the manual? Who were the other persons on duty? He even asked for a handwriting expert. My own layman's eye into the bundle shows Mr. Harris's signature does not look like the same on the check. But I'm not a handwriting expert. But that was a question.
Was that just intended to prejudice us? You confess there is no probative value in your statement, yet you utter it.
But what is reasonable, Your Honor, is a question that the ordinary man in the street must answer and be satisfied. Was it reasonable for an employee in these circumstances to dismiss that particular employee on this charge?
So, sir, what is the basis of your unhappiness? Is it that there was not a sufficient basis on the first offense, quote unquote, or was it that the procedures were not complied with? Because the latter approach seems to me to be much more cut and dried. You're saying that in any event.
In any event.
Yeah. Okay.
Right. So I'm just saying that, and I'm just following my learned friend's arguments, that this was so outrageous a decision of the tribunal that it has to be an error of law. Doesn't hold water in my view, because the objective test as to the reasonableness of the dismissal or unreasonableness of the dismissal.
No, but he tried to cover that by reference to the, is it offense 10 and 11?
Yes. And even number 9, which precedes that. If you were to put them on, Mr. Harvey had difficulty in trying to put this offense under the category. He had great difficulty in trying to identify what other example other than Mr. Harris's infraction could be one of these.
But why doesn't it fit on the offense 11?
It's on the screen.
It's on screen. Wait, sorry. My submission is that the tribunal's assessment of the circumstances was that it could not amount to an offense under number 11 at the first instance. I'm
not sure I'm following that. I mean, what is it in 11 that was not satisfied?
Well, 11, the only punishment in 11 is dismissal.
Right.
If this were negligence or incompetence,
he didn't look at the back of the check, which you said you agree he should have done. So is that not negligence?
Well, I don't think Mr. Harris in his evidence has ever said that he agreed that he did not look at the back of the check. I believe Mr. Harris's case is that he's never seen the check. So one cannot look at the back of something that one has not seen. And that is Mr. Harris's case. So I do act.
Mr. Nicholas, you need to be very careful because you may be going deeper in than you want to. Is it certainly, I would have thought, it is accepted that his responsibility, forget about back and counting, was to one of his supervisory responsibilities was to look at the accounts to make sure they were reconciled. Why would you say, how can he, if he does not look at the check, is that, you put that in 11? If he never even looked at the checks, where are you going to put that? I don't think you really need to go that
No,
way.
I wasn't saying that he never looked at a check. I'm saying he said he never saw that check.
Okay. But there is no dispute before us that check was issued and cashed and the payment was
On the night in question.
And
he should have seen the check.
should have seen it.
But I'm saying that it may also be possible for someone wanting to deceive or defraud to slip it in at an appropriate time. I'm saying the investigation did not go far enough to unearth whether that was a possibility.
But tell me something. If, assuming that it was in the bundle of checks he looked at or should have looked at, and assuming he didn't look at the back, the money was already paid over, wasn't it?
It was a
At that time, Chefette would have already suffered the loss.
Correct.
His looking at the back and discovering something is wrong here would not have prevented the loss. The loss would have already occurred.
It would have already occurred. And they would have been able to ascertain who, how, and what. And it is very interesting to look at the witness statement and the evidence of Maria Wallace, the cashier, because her evidence tends to support the position of Mr. Harris, because she said, if this were a manager's check, I would have known. I would have remembered, because it is a different type of check than the ordinary Chefette checks. So that the argument that the decision of the tribunal was so outrageous, in my mind, doesn't wash, because it is very clear that, and the reason why they didn't investigate more, the reason why they didn't act on his suggestions, he wrote a letter after he was suspended. And they're now accepting that the suspension, today is the first time I'm hearing it, was not because of this action, but because he was loud in the meeting. So that, and then I'm trying to reconcile, if it were not a disciplinary meeting, only an investigatory meeting, how could your responses, as low as they were, amount to you being dismissed for the very disciplinary infraction? I mean, so a lot of what Chefette is saying is so incongruous, but at the same time, a reasonable man sitting on a Bayfield bus in Bridgetown would not accept that Chefette acted reasonably in these circumstances to dismiss a 14-year assistant manager with an otherwise impeccable record on this evidence, despite his protestations.
Even if his conduct came within offense 11. This is what I'm trying to get from you, because I think it might be difficult to say that it doesn't come within 11, because basically earlier you conceded that, you know, he ought to have looked at the back, and he did not. But let us assume for the moment, that it came within 11, and the sanction that's dictated is dismissal. I think I'm asking you, does that still then come within the concept of reasonableness, even though it says dismissal? is the concept of reasonableness still disciplining what Chefette can do to the employee? And if so, where do you get the legal basis for so saying?
Right, so even if there is misconduct and a proven breach of the process,
Yes.
and the disciplinary code says dismissal,
Yes.
an employer acting on that disciplinary code without more does not make the dismissal fair, does not make the act of dismissal reasonable.
Got you. So what is the legal basis for that?
It is found in section 29(4) of the Employment Rights Act.
A.
Can you put it up for us?
You want it? Yeah, section 29(4)(a), where the employer has fulfilled the requirements of subsection 1, the question of whether the dismissal was fair or unfair, having regard to the reasons shown by the employer, shall depend on whether the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee. So that there is, the answer to that is not that it is in my code, as what the Chefette is saying. There is to be an objective assessment carried out by the tribunal as to whether, having regard to the reasons shown, whether the employer acted reasonably or unreasonably as treating it as a sufficient reason, so that the reason has to be sufficient for dismissal. And therefore, that objective assessment has to be carried out by the tribunal by looking at all of the factors. And to
Including,
say-
for example, the 14 years.
Yes.
That he had served basically unblemished. I want to do
Yes.
small things, but.
And the adequacy of the investigation that should be carried out in these circumstances has to be measured against something. And that is the gravity of the charges and the likely punishment if the misconduct is found to have occurred. So that these are the steps that the tribunal must assess the evidence. So to say that the tribunal was so offensive to suggest that this large fast food chain ought not to have been looked at as having the resources to carry out a proper investigation. And the tribunal said, we cannot discern what other information that you have unearthed since the first meeting. There's no other information.
So at page 370 of the record, you have the tribunal making its serial pronouncement in this regard, where it says in the first full paragraph, it appears, page 370, it appears from the foregoing that the type of offense of which the claimant was accused could result in dismissal,
Yes.
but that dismissal is not an automatic sanction for the first offense. Then you skip down 2 paragraphs. Even where the evidence against an employee would justify a finding of gross misconduct, dismissal should not be an automatic response. And then you go down to the last paragraph before the new subhead. 3rd sentence, it is our view that when the mitigating factors are balanced against the misconduct of which he was accused, it was outside the band of reasonable responses to dismiss the claimant for a first offense of that nature. So that is what the tribunal did.
Yeah, that is what the tribunal did. And I dare say that in making that assumption,
Sorry, it's not an assumption. It's
sorry,
a fact.
making that finding,
Determination.
that determination of fact, it is not so outrageous that it has to be reined in by a court as an error of law.
Okay.
So that the ineluctable conclusion was that the tribunal, sorry, that the employer in this instance did not act reasonably
Okay.
in dismissing this particular employee. However, I do want to touch on the argument in my submissions, which I didn't hear my learned friend respond, and perhaps he might do so in his reply. When I read the Court of Appeals decision, it is clear that the band of reasonableness approach, and there was a lot of argument back and forth, and I must say I did feel very sorry for counsel in the Court of Appeals facing the barrage from the court, and I say that in the most respectful way, and the searching questions as to whether you can just import this English standard where there is a very glaring omission of principle statements of law in the section, which speaks to equity, justice, and fairness in the application of the reasonable band test. I do not accept that as a Court of Appeals view, but it is our submission, Mr. Harris's submission, that where the employer does not comply with the mandatory disciplinary procedures under Section 29(5) of the Act, he is disentitled to say that the dismissal was reasonable. So that the Section 29(4) argument, or the exercise of ascertaining the reasonableness or unreasonableness argument, is not necessary. That is the ineluctable conclusion of the Court of Appeal. I mean, this court is quite within its province to disagree that that is the proper interpretation of the section. I think my learned friend would agree with me that employers and employees alike in Barbados want to know if that is the final conclusion, because I do have matters where employers trying their very best to observe what they understand to be these procedures, but they have run afoul of something. Is it as strict as it is and it ought? That is the Court of Appeals view, and my learned friend,
You agree with that view?
I do agree with it, and that if it has to be softened or changed, the only place that can do that is the Houses of Parliament in Barbados. And it has to be addressed as to...
You are basically advocating for a box checking exercise.
No, I'm not advocating that, Your Honor.
No.
I'm saying...
Supporting it.
I'm saying that the interpretation, it is difficult to...
No, that's what I mean. You are saying that unless Parliament changes it, this court must give the plain meaning to the words in this limited section, which say condition precedent to dismissal must be compliance with these procedural preliminary steps.
And the reason why that...
Yes.
Sorry.
Is that what you're saying?
Yeah, and the reason why that might be a difficult a proposition, but I have to accept.
Do you know, Counsel, you refuse to say yes?
I will leave
My
that.
brother has invited you twice to say yes.
If you may permit me to answer it in this way, it is a difficult proposition, but I must confess, on reading it, you will have to say yes. Because of the wording of the section. In the English section 98, the word "and," which is conjunctive, is not placed where it says, could you pull up section 29(5)? The wording is different. And I always have a difficulty. If we're going to give a broad brush approach to interpretation of statute, we must respect the language used by the lawgiver. And is it permissible to give a purposive approach to interpretation where the language is starkly different? I would say, as difficult as a proposition is, as difficult as it is to accept that there is a box-ticking standard that might be onerous on the part of an employer to follow, that is what the law says. And if we are to interpret the Employment Rights Act in Barbados as similar to how the Employment Rights Act in England is interpreted, then we have to get around the difficulty in the
This
language.
is a matter of curiosity. How many boxes are there to tick? This is a box ticking exercise.
Well, they use
There's
the
a-
conjunctive and between all of it.
Sorry, section 29(5). It will be in the schedule, where that section is interpreted. If you can find it for me. I do believe that the Court of Appeals, if we were to look at paragraph 1 of the judgment in the Court of Appeals.
But in this case, you agree with the Court of Appeal?
In this case, I agree with the Court of Appeal, and in answer to the question...
in another case?
Pardon me?
Not necessarily in another case, but in this case, you agree with the Court of Appeal?
I agree with the Court of Appeals ruling, full stop. And I would not say I wouldn't have a difficulty where in Mr. Kisu's case. I mean, I had a case where the employer wrote and said, you are guilty of misconduct, gross misconduct, and come and attend a meeting and stuff. And they sent all of the statements and all of the things that they were intended to rely. And the advocate for the employee said at the meeting, but you did not specify what gross misconduct was. So therefore, there's no need for disciplinary meeting. You have not conformed with the section. Let's start damages. And I'm saying that the employer settled in its layman's mind gross misconduct and set up all of the information it was relying on. And the employee participated in the initial meeting. So it was on appeal, that the lawyer said, well, you didn't comply, you didn't specify what was gross misconduct. Although you had all the statements upon which the employer relied. And so the question is, how strict interpretation would we give the act?
You're carrying me to the paragraph in the Court of Appeals judgment. Were you able to find it?
Yes, I was trying to find...
Is that 68 where it repeats the section 29 of the ERA, or?
68?
I'm just wondering. This is where it repeats the provisions in...
Yes, section 68.
And following.
And follows from there. And I think paragraph 77 is where... No. Oh, paragraph 76, in answer to the question of ticking of the boxes.
Yes.
This is where the court sets, so in its own interpretation, how you must approach section 29. The upshot of the foregoing then is that in determining whether the dismissal of an employee is fair or unfair under section 29, the tribunal must have regard to 4 conditions. These are: 1, whether the employee has met the criteria in section 27.3 necessary to qualify for the right in section 27.1 not to be unfairly dismissed.
That's not for the employer, right?
Right.
That's an employer, okay.
If so, whether pursuant to 29.1 and 2, the reason or principal reason for the dismissal of the employee related to the employee's capability or conduct, or to some other substantial, well, that should be substantial, other statutory reason that justifies dismissal. If the reason relates to capability or conduct, 3, whether the appropriate statutory disciplinary procedures were complied with pursuant to 29.5. And if the reason for dismissal relates to reasons other than capability of the employee or conduct of the employee, or if the reason relates to capability or conduct of the employee and the employer has complied with the procedural requirements under section 29.5, then the next step is 4, whether dismissal was fair under 29.4. So that is as difficult as it is to work out here for the ordinary employer, HR officer in a company.
Because one of those in 29.5, am I correct in saying, is to inform them of their right to bring someone along?
Yes,
right?
correct.
So that they write the letter, the employer, and they say gross misconduct. They give you the supporting documents, and they even give you particulars, and they don't say you can bring along a friend.
Correct.
They leave out, I think that was 3 or 4, I can't remember now. They leave that out. But you know the charge, you know the particulars, they've even given you, quote unquote, the evidence that they have. And they say, well, look, turn up at a meeting. But, of course, they haven't told you you could bring along someone. Correct?
Correct.
But what does the Court of Appeal suggest? That failure,
Alone.
well, is one of the things that it's supposed to do. Yes, that failure alone means, to use your language, non-compliance with Section 295 of the Act means that they are disentitled to dismiss. That's what you told us. So they don't tell them, bring along a friend, because the section doesn't even say bring a lawyer, you know.
You didn't say
Just
my
bring
friend.
a friend, walk with anybody.
Yeah.
Don't tell you that. And they are now, in your submission, disentitled to dismiss. Now, let's suppose the evidence was a video recording of the hand in the cash register. You know what I mean? But they didn't tell them, bring along a friend. Are they disentitled to dismiss?
Well, that, Your Honors, that is a difficult question, but on the interpretation of the Act, it would seem that that is the ineluctable consequence
And
of
that
a
is
failure.
fair and just and reasonable in relation to the employer.
And that is,
What the statute requires.
it is correct in law. But you see, the problem is that whereas the English statute,
No, don't tell us about the English statute, tell us about the Barbados
the
statute.
Barbados statute does not give that statutory, that textual warrant to test the dismissal on that basis. And one may even argue, what was the intent by omitting that language in applying generally what was the schematics of the 1996 Act to Barbados? What was the intent to omit it? So that is why I asked.
There are cases in terms of public law where the statute does not say that you must give a person an opportunity to be heard before you take disciplinary action, and the courts have read in to the process based on the principle of the constitutional warrant for fairness to say that procedure must include an opportunity to be heard. This is not quite that. Is there a place in this if the legislation is intending to achieve equality, because there is obvious asymmetry in power, etc. Equality, fairness, and reasonableness. Is there room, legitimate room, to read in to the process these principles?
That, Your Honor, is a difficult jurisprudential question for an advocate at the bar.
You leave that to us. You won't answer.
Because there are two schools of thought which can be equally persuasive. The statute is not perfect and was never intended to be writ on stone and handed down on Mount Sinai. It has to work, and then the process has to allow for amendments to the statute where practice and procedure and circumstances justify that amendments need to be made to ameliorate or to soften approaches and what's not. That is one approach. Then the other approach is that if this is a statute that is supposed to bring substantive justice in the employment workplace and to balance the rights between employers and employees, where fairness now pervades the employment contract, is a court to shut its eyes to a textual omission to instill or to write in justice and fairness and equity in the circumstances.
That's what we're asking you.
And then there's the third one. The third argument is, having omitted it, is the court not supposed to give fealty to the language of the legislature and not to the lofty, aspiring predilections of the jurisprudential scholars as to what Parliament omitted? So those are questions that only could be settled by your lordships, and certainly as a student and a teacher of law, this court has not shied away from its responsibility to set down what is really the law and the true intent of it. So that Your Honor, is not a question that I would want to surmise on, but we would be grateful for some guidance as to whether a simple failure in one of those procedural requirements justifies, where the hand is caught in the proverbial cookie jar, the the employee is now entitled to a windfall because of a slip-up of a simple procedure. Could that be justice? And this, as a final court, is well praised and well placed to make a pronouncement on that. But I must say in this case that this was not a simple situation where there was one procedural error. There were several procedural errors, and the tribunal makes that in its finding, that in this particular case, the procedural errors were so rampant and so egregious that it could not justify dismissal. They didn't follow Mr. Justice Burgess' his formulation in paragraph 76 of the judgment. They did the inverse. They did the section 29.4 argument before the section 29.5. So they went to the band of reasonable responses and came to the conclusion that it was not a reasonable response to dismiss in these circumstances. And then it went to the procedural elements and it went through each of them and also found that the dismissal did not amount to what was required under the legislation. My submissions are very clear. Having interpreted the law and in agreement with as harsh the reality that presents itself in the Employment Rights Act, Section 29.5, the procedural elements precede or are required to be complied with before the tribunal can look at whether or not the dismissal was unfair or not. Is there any avenue by which the legislature can be made aware of concerns, perhaps, in the... Certainly, the judgment of this court is the highest authority to which the Parliament must take, well, I shouldn't say Parliament, the executive must take its guide. And it has been a practice, as I understand it, in Barbados to follow and respect the rule of law. And where I always like to say that the courts do respect the right of the executive, provided that the courts respect the right of the executive to determine what is the law, provided the executive respects the right of the courts to say what its limit is. Yes. No, yeah. No, I think we might be on slightly different wavelengths. What I'm saying is that if it becomes obvious that there are difficulties or significant areas of ambiguity, for example, we discussed the issue of whether there's a cap on 1B, for example, whether that's desirable. What I'm wondering is whether there's any institutional arrangements, because in Barbados you have all of these partnerships, employers, employees, and so on. Certainly there is the social partnership, yes, where that has been very useful in bringing labor, government, and the employers, and now they've added the NGOs to a situation, and I but not the church together. Yeah, but I must confess, I did have a conversation with someone on certain other aspects of the act, which led me to believe that it is actively being considered. And may I give an example, Your Honors? Redundancy, or I should say, not redundancy, I say retirement. In the UK, when this act was first passed, if you retired someone, it did not run afoul of the legislation. But what they've gone on in the UK to do, to say, well, you just can't say 65 arbitrary. You must now look at whether 65 is the age at which the industry standard or you in the past have observed, and what are the arrangements the employee has made, and so forth. So there are a number of factors. In Barbados, we have a situation where it has now come up whether or not the retirement of an employee has to comport with the issue of competence and capability under Section 29.4, which is at present in the English legislation by way of statutory amendments, but it is not in Barbados. So how do you treat to an employee who has been retired but is claiming that you only sent me home on retirement at this age because you have a problem for my capability? How is that resolved? So that the act itself, in my view, needs work, and perhaps this court should properly ask the stakeholders or to suggest to them that they should take a look at it, because even how we treat the disabled employees or employees who have has significant injuries, where in England there is a requirement to do everything to ensure that an employee who has a substantial disability is able to work, whereas that is not the culture in Barbados or in the Caribbean. We go in the opposite direction. So that how do we balance these things, and so that employment law is really a work that has to be continuing, and I don't think that it could be one that is set in all time and rests there. It is an evolving construct. So I do accept your Honor's invitation to submit some more on the question of what is Section 1B in the compensation, because it needs to be fleshed out. But certainly, I would think, and back to Your Honor, Mr. Justice Barrow's point, that the courts can use the principles of law to circumscribe the whole ambit of that. But certainly, I wouldn't think that you can just arbitrarily set a limit where Parliament did not set the limit, because it would therefore deprive the tribunal in a particular circumstance where the facts and circumstances so warrant of making a compensatory award to someone. And in the absence of a statutory cap in these circumstances, it would not be right, particularly when the tribunal has made some awards of compensation and the Court of Appeal has not opined on it as yet, or in any extensive way had the opportunity to do so. So to ask this court to set ex cathedra a cap in circumstances where Parliament has not so limited the jurisdiction and discretion of the tribunal would, to my mind, be a stretch. And it does not mean, in this particular case, the justice of the case, because, as I have submitted, though errors of law has been committed by not allowing, not as my learned friend has said, the cross-examination, but I would say the continuation of the cross-examination, because it did start. The tribunal did make the allowance to reduce his losses by some $11,000 on account for his earnings as a security guard. So in this particular circumstance, this court must take cognizance of the fact that some mitigation was applied to the damages, and it's not a situation where they were hamstrung and he's gotten a cash award, a lump sum. He's gone bingo, because there has been no attempt to mitigate his losses, and he's got a windfall that was unjust, and that is certainly not the case. The approach of the tribunal may be wrong, and I quite agree, but at the end of the day, there was no unjust award to Mr. Harris.
Okay, we've done the compensation bit already, Mr. Nichols. Is there anything else you wanted to tell us?
Just permit me just to get a quick glance at Mr. Lerner's friend's appeal, grounds of appeal. No, Your Honors. Unless there's any particular issue, I do rest on my written submissions to the court.
Okay. Thank you. And again, I remind you that you and Mr. Kisoon, this for your benefit as well, you will have, we'll give you 2 weeks, let's say to the end of the year, because 2 weeks carries us up to the 25th, and nothing happens between the 25th and the 31st, basically, to provide us with further submissions on the issue of compensation, and in particular, the approach that the court should take in relation to Section 1B of the 5th schedule. Mr. Kisoon, do you have anything to say in response?
No, Your Honor. Rest on.
And you will provide us with some case law and so.
Yes. Yes, well, naturally, the submissions will be accompanied with case law. Well, thank you very much, Counsel. We will let you know when we are ready with our decision, which, of course, will be sometime after you've given us the submissions on the compensation.
All right.